With you telling Lyle what?
My dad had been molesting me.
This Andy Cano 1988 supposed letter weighed it in the continuum of lies.
I ran around and shot my mom.
The court should deny the current habeas petition by the Menendez brothers.
DA Nathan Hochman opposing a new trial for the Menendez brothers, citing shaky evidence and changing stories. But the convicted siblings still have a slim chance at freedom. We're talking about what comes next for Lyle and Eric Menendez. Plus, investigators are searching for a woman who allegedly murdered her fire captain wife. Not only is the suspect in the wind, but she's killed a spouse before. Also this hour, we're looking ahead to closing arguments in the sleepwalking twin murder trial. Someone who's personally experienced sleepwalking is opening up this morning about what is possible. And accused murderer and children's book author Kouri Richins will soon be facing a jury picked from her local county. But the location of the trial has yet to be decided. We're talking about the brand new rulings that could be tipping the scales of justice in her case. It's all coming up next for you right here on Opening Statements. Good Monday morning to you and welcome to Opening Statements. I'm your host, Julie Grant. And we hope you had a great weekend. We planned a great show for you to get your Monday started. So go ahead, grab that cup of coffee right now. It's time for my opening statement. Justice is resurrected. The new district attorney is opposing the Menendez brothers' push for a new trial. Good. He very clearly and transparently explained the legal rationale for his opposition. And his comments, let's be clear, were not about resentencing. He's going to share his position on that next month. The Menendez's legal team is pursuing 3 different ways to try to get these guys out of prison. The third way is a request for clemency from the governor. But on Friday, District Attorney Nathan Hochman explained why a new trial isn't legally proper for these killers. And through his explanation, we learned some very enlightening things. Did you know that the brothers changed their story 5 times? First, they blamed the mafia and they created a fake alibi. Later, when they started claiming molestation, they initially said Kitty molested Lyle. Then they came off that story and they accused only Jose. And did you know that they made multiple efforts and had some success at suborning perjury? That's right, they tried to get outside witnesses to say certain things and lie for them. For example, one of the lies was that Jose violently raped a girlfriend of Lyle's. They gave a script to a witness to say that Kitty tried to poison the whole family. And they wanted another witness to lie about them being afraid of their parents and to tell the court that they asked to borrow his gun. The Menendez brothers are not only murderers, they're also major liars. The district attorney, he seems to be a true minister of justice, exactly what a prosecutor should be. He acknowledged that sexual abuse is abhorrent, and he's committed to prosecuting such cases. And despite all the deceitfulness, the fabrication of evidence, and the manipulation of the investigation carried out by Lyle and Eric Menendez, District Attorney Hochman still gave them the benefit of the doubt, saying that if they were molested, it might serve as motivation for the murders, why they did what they did. But he was firm that in no way does it constitute self-defense on the night that they shot their parents 12 times. That's my opening statement. Let me know if you like it. Right now, it's time for your daily docket.
Did you ever hear, in all these hours and all these multiple operations, the defendant ever say to Rob Baker anything of the nature of, "Oh my gosh, did you kill the father of my children"?
Never.
Oh, in California, we've got the state's case continuing in the celebrity hairstylist murder trial for Monica Cementilli. That's going to start up at noon Eastern time. In Texas, we've got closing arguments expected in the Sleepwalking twin murder trial for Benjamin Elliott. Wow, that is a fascinating case. 10 a.m. Eastern time is going to be the start time, but we're on a 2-hour broadcast delay per court order, so you'll see that trial starting up this afternoon. And in Florida, we've got a brand new trial starting this morning. The bedtime murder trial for defendant Jermaine Bass. This guy is accused of shooting his 2 children, killing one of them, 5-year-old Jayla. Opening statements start up at 8:30 a.m. Eastern. We're going to go in there live together when they do. Now, let's turn to our top story. What is the next move for the Menendezes? Los Angeles County DA Nathan Hochman saying that Lyle and Eric Menendez do not deserve a new trial for the premeditated murders of their parents, Jose and Kitty. Let's look back at the moment where Hochman described the 5 different versions of events that these guys told.
Eric and Lyle Menendez had told 5 different versions of the events of what had happened. The first version that they told is that they did not kill their parents. And in that version, again, they said it was a mafia hit. And they had the police investigate whether or not Jose Menendez had been killed by the mafia. The second version was that their father was a violent sexual predator who raped Lyle's girlfriend. The third version that Lyle told was that their father had molested Eric, but the mother had molested Lyle, without any mention of Lyle being molested by his father. The fourth version is that Eric and Lyle were both molested by their father. And the fifth version is that both their father and their mother were going to kill them the night of August 20th, 1989, which is why they shot them first.
My goodness, this was a savage, savage crime. You know, and a lot of these things we learned at the press conference, we didn't see in the series or the documentary. A lot of really enlightening information shared. And there's more. The DA's office put together a link on their website for anybody who wants to look at the procedural history of this case. They've lost habeas motions before. They already lost a state habeas motion. They lost a federal one. So what's the next move for these guys? And what do you think of the DA's move to oppose their habeas motion for a new trial? Let us know. Let's bring in our power panel now. We got 3 great guests standing by. Jennifer Coffindaffer, Tommy Pope, and Kirk Nurmi. Good morning to you all. Jennifer, let me start with you. Your reaction and thoughts on what these guys may do next.
Well, what I really thought was key is the fact that they looked over tens of thousands of pages. That's what his team did, and that's why they were able to make all of these conclusions. Listen, for those of us who have followed this case and know this case, there was nothing really that new, but so many people got caught up in the hype and all this information that really was brought in well after and was not corroborated, Julie. I think their only hope is clemency.
Oh, good point, Jennifer. Good point. You know, so that would be the second avenue for them, right? The petition for clemency. That's Gavin Newsom, the governor of California, could make a decision on this. The petition, the DA noted, is on his desk. The DA said he can do what he wants with it. Let's see what comes next month, too, in the resentencing. 2 options for the Menendez brothers, but does it look good? Tommy Pope, to you next. Your thoughts on all this, please.
So, one, the new prosecutor, I thought he did exactly what he was supposed to. You know, when we had the former prosecutor, it was like he was just going with the narrative of the TV show. And we can't try cases and have justice ministered by whatever version of the TV version we see. And so I thought he dug into the file, didn't let the pressure of the sentiment from the TV version push him, and made a sound decision. Unfortunately, I've had similar experiences with some of my cases where what I thought the story was till I saw it on Dateline and find out that wasn't quite what it was at all. And like you said, they'll leave out parts that don't go with the story narrative, but that's not the prosecutor's job. The prosecutor's job is to seek the truth, and I think he's doing exactly that.
Right, it sure is. Tommy, thank you for that. Kirk Nurmi, last but not least, want to get your thoughts on all this, please.
Yeah, I would think I take a contrarian point of view here. I think if DA Hochman was so certain about the assertions he's making from the podium, he wouldn't be so nervous about a retrial. He wouldn't be opposing a retrial. Likewise, the assertions he makes, everything else, really stands in defiance of what we know about childhood abuse, childhood trauma, the stamp that can put on a child's brain, as well as child abuse accommodation syndrome. So he stands really in defiance of all those things when he makes these bold assertions, making himself a tough law and order guy. But ultimately, I think this really wasn't the preferred avenue by the Menendez brothers anyway. This would take a year or more to get going. So I think when we talk about resentencing, a California law that would allow for that after 25 years based on the age of the commission of the crime that's come into play, as well as what Jennifer mentioned, clemency, which I think has really become more realistic now, because when we see DA Hochman making this a political deal, making this political stance, I think it gives more room for someone like Governor Newsom to take some of those issues that I just talked about, understand the reality of those issues, and really give deeper consideration and clemency to the Menendez brothers.
Kirk, excellent points. Thank you for all of that. Jennifer, I want to go back to you on one of the pieces of evidence that we're aware of that the Menendezes were citing as a reason or basis for a new trial that we heard DA Hochman refuting, the letter that Eric wrote to a cousin, not dated, but not introduced at the first trial. Your thoughts on this as a piece of evidence and DA Hochman's response to the argument that, oh, you know, this is something that corroborates the molestation?
Well, this piece of evidence, quite frankly, is so flimsy. First of all, it is a photostatic copy. It is not dated, as you mentioned. Also, it was supposedly in existence before the original trials, I should say. And in addition, both of these witnesses testified at the trial and never brought up anything about the letter. Again, the letter that was purportedly written well before the trial, well before the action. So it's really flimsy and does not stand prima facie as good evidence.
Right, so well said, Jennifer. You know, he refuted that, and then he refuted the claim from one of the members of the boy band Menudo, who's come forward and said that he was molested. And the way the DA didn't challenge whether it occurred, what he said was, well, this has no place. It's neither here nor there when we're looking at a habeas motion for a new trial, because they were unaware of this at the time. It wasn't going to influence them or their state of mind on the date of the crimes. Tommy Pope, he was really fixated on what they knew at the time because they put forth this imperfect self-defense claim. Your thoughts on the DA's points regarding that?
Well, I've got to measure my prosecution answers very carefully because I see Kirk's got his defense hat on today, so I got to step up my game. But I think those are subtleties. And again, most of these end up playing out in the record and in the courtroom. And so I think that the fact that it occurred is corroborating something that would not have had any effect on whether they committed the crime or why they committed the crime. So I will add before I stop that trying a case 25 years later, I've had some old cases that have come back, and it is extremely difficult. So as a prosecutor, I'd probably be fighting habeas corpus too, Kirk.
Tommy, thank you for that. And Kirk, okay, fight it for us. So give us the opposing point of view, these two pieces of evidence. Your thoughts, please, Kirk.
Sure, I think as it goes to the letter, Jennifer points out that it was written before, but it wasn't discovered till after the trial. So that argument becomes moot, really. And ultimately, too, we also have to understand that handwriting analysis can give us a sense of whether or not this letter is authentic or not, whether it was written by the author or not. So to say that this is a moot piece of evidence really isn't in conjunction with what the law states. You combine that with the testimony of others now that are talking about being victims of sexual abuse, it may not, mitigate or doesn't alter the fact that they killed their parents, but it does lead us possibly, and I think a good argument can be made, especially when we've talked about from jurors who did not believe that boys could be victims of sexual abuse from the first trial when it was precluded from the second. It is something that has changed now and could, in fact, mitigate the crime to a second degree or a manslaughter, which mean they would be free. So again, I think you're really acting without full interest in looking at all the evidence to take a particular position as opposed to really looking at this fairly.
Kirk, thank you for the opposing viewpoint. So looking ahead here, we know these guys have two options, assuming that the court denies their habeas motion. We know that the state's going to strongly oppose it. They're going to look to the governor, perhaps for clemency, and then to the court for resentencing. We don't know what the DA is going to do, but it sounds to me like he's going to oppose that as well. Jennifer, what do you think the likelihood is at the end of the day of these two getting out of prison and going back into society?
I think the likelihood is quite slim, but I do believe that depending on the governor's stance on this case, and more importantly, his political agenda that is going to be in the background of all of this, whether he needs this for his constituency to agree with re-electing him, I think that could play a role. And I think clemency is the only possible viable action, because I don't think legally the other two will go.
I think you're exactly right. You're exactly right. You know, and Nathan Hochman did a great job highlighting how these Menendez brothers have made these arguments before. I mean, things have failed and failed for them. This is the second habeas petition in state court. One in federal court was denied. So you're right. I think they're going to put some pressure on Governor Newsom. We've got to leave it there for now. But thank you all for the robust discussion on these convicted killers. We're going to take a break. When we come back here on opening statements, here's what we've got.
I think my family is supportive of finding the truth and getting men help that's appropriate for what the truth is. And I believe that it is sleepwalking because we have a history.
What will the jury find when they get the case today in the sleepwalking twin murder trial? But first, the wife and the suspected killer of the California fire captain is in the wind. And if she's caught, this won't be her first homicide case.
911 emergency.
Can you get someone over here now?
Well, okay, what does he look like?
He's O.J. Simpson. I think you know his record.
They were broken up, and he was still madly in love with her.
He didn't think that he was a batterer. And I said, hey, man, you hit her. You're a batterer.
This is a murder case. They felt it had nothing to do with the murders.
Trial and Error. Why did O.J. win? A Court TV original series. New episode Sunday night, 8 Eastern and Pacific. Only on Court TV.
She was always positive. She was never rude, mean, or grumpy to anybody in any situation at all. With Becky's case, you know, being so close to retirement and just the person that she was, I think is going to be one of the harder things to for people to take a little longer to get over.
Now for what's trending in true crime as a community mourns the death of a beloved fire captain. Her suspected killer, her wife, is on the run. This is Yolanda Marodi. According to the San Diego County Sheriff's Department, she's the main suspect in the fatal stabbing of fire captain Rebecca Marodi. Rebecca, who is known as Becky, was found dead in her Southern California home last week. Becky and Yolanda had been married for just over 2 years. A week after Becky was found dead, Yolanda is still at large, and authorities are asking for the public's help in finding her. So, our first question we're asking this morning, where might she be hiding? Let's bring back in Tommy Pope and Kirk Nurmi. Tommy, drawing on your experience as an investigator, I want to start with you. Where would you be looking for this lady?
I think they actually are looking south of the border, and I think that's good. You know, I always am concerned from a law enforcement standpoint about across-the-border cooperation, but in the article that you guys had posted on your site, it appears that I think it's Baja, that down in that region that they are working. But it was interesting the way they had their press release or whatever. They said they would look, but it it's like they were keeping their options open to say whether they would acknowledge whether she was there or not. But I think that's the right location because of the proximity. And normally these kind of cases are a spur of the moment, heat of passion. It's normally not planned like we saw the one over in Greenville with the rose petals and everything. It's more of a spur, but these stabbings tend to be domestic. They tend to be personal. And so I would think she's close, and the quicker law enforcement gets on it, the more likely she'll be found.
Yeah, a great point. Kirk, to you next, please. Where do you think they might be looking for this lady?
Yeah, I agree with Tommy. The San Diego area is so close to the border, and not being a suspect at the time she crossed the border would allow her a certain carte blanche to go wherever she wants to go. A woman who has spent, I believe it's over a decade in prison for the killing of a former spouse. So, to echo what Tommy says, you don't know how hard these people are looking, but at the same time, you do know that this is a dangerous woman. She spent over a decade in prison. She's now maybe committed 2 homicides at this point. So she is probably a danger to herself and others, and is going to do everything she can to fight returning to prison. So hopefully there is some urgency in their search.
Yes, well said, Kirk. I want to play a clip for you both. One of Becky Marodi's co-workers sharing what it felt like learning of her death.
My computer was firing up. Saw one of the other PIOs in the office here had a badge shroud on and asked who we were shrouding for, and that's when she told me that the email had come out and that it was Becky.
Now, Becky Marodi suffered stab wounds. Her sharp force entries and court records point to eerily similar facts between her wife's first and second marriage. Okay, so here's the bottom line. Yolanda Marodi has killed her first spouse. She stabbed her husband, James, and I hope I'm pronouncing this correctly, Olajenizak, stabbed him to death. And she did prison time for it. Sentenced back in 2004 to 11 years. She pleaded to voluntary manslaughter. She got out in 2013. So, the next question is, do we think Becky Marodi knew about her wife's deadly past? Tommy, back to you.
I would think she at least knew her version of it. In other words, she probably had some way of knowing she was in prison. I always think if you got a relationship where I'm starting to run a background check on you, I probably shouldn't be in that relationship. But I think that's probably she knew, but she probably was explained that, he was a horrible person or a spousal abuser or something that justified it and made the defendant seem like a victim. And so it wouldn't surprise me that Becky knew it, but obviously never envisioned it happening to herself.
Mm-hmm. Right, Tommy. Kirk, to you next, please. Your thoughts on that?
Yeah, it's just tragic, and I think Tommy's right, because, you have a situation, and you see it over and over again in a lot of these cases throughout my career anyway, family members who, their love blinded them to the reality of what was going on, of what their partner or their loved one was doing, right, whether it was their child or their spouse. And I think that's this kind of situation. I think Tommy's right. I think it was told in a way where she was the victim of all this. She was the victim of circumstance. She went to prison because of reasons really unrelated to her. She's the victim, and she's totally changed her life, and obviously that is proven not to be the case. So do I think she knew? Yeah, I agree with Tommy. I think she knew her now accused killer's point of view anyway.
Mm-hmm. Kirk, thank you. It's eerie too. They're both stabbing cases, isn't it, Tommy? That was the method used to kill her first husband, and if she did this second homicide, we don't know. She's just suspected. Interesting, same method used. Your thoughts on that?
Yeah, I'm always thinking of it in the courtroom and prosecuting it if it comes to it. And, I don't know the law in California per se, but, we have prior bad acts, and you have to weigh the prejudicial versus probative. I would say that the stabbing component, of a prior spouse is extremely prejudicial, but it is also extremely probative. And so, if the similarities, the more they mesh, the more likely you have like a common scheme and plan, or there's several different areas of the law that allow that in. And so I could see that very well being the turning point in the case, independent of whatever facts they have. And obviously it's an appealable issue, and we hadn't even gotten her arrested yet.
Yeah, great points. Yeah, looking ahead to trial, hopefully she's apprehended. We know she's the main suspect. If she didn't do it, then she'll be let go. But let's hope that they're able to find her and bring some justice for this fire captain, Becky Marody. We'll leave it there for now. Tommy and Kirk, you're coming with us. Stand by for more questions, please. Still to come here on opening statements. Here's what we've got for you.
Show you that Benjamin Elliott was having a parasomnia, that there's no chance, no motive, no reason for him to do this, that he suffers from this to this day. And at the end, we're going to ask, did you find him not guilty?
Closing arguments happening today in the Sleepwalking twin murder trial. Plus, defendant Kouri Richins, the Utah mom accused of fatally poisoning her husband, is back in court, and her defense team is trying to find the perfect jury. Welcome back. This morning, we're turning the spotlight on the Sleepwalking twin murder trial. This one's happening in Texas, and we're anticipating getting to the closing arguments and then the case in the jury's hands today. 21-year-old Benjamin Elliott is accused of stabbing his twin sister Megan to death while he was sleepwalking, is when he says it happened. He was 17 years old at the time. Prosecutors believe that he was awake and intended to do it. They cite his cell phone activity right before the stabbing. The defense team says he suffered from something called parasomnia and that he never meant to harm her. His mother agrees.
Do you know of any reason why your son would intentionally, knowingly cause the death of your daughter?
No. Wow. So 2 sleepwalking experts gave differing opinions. Surprise, surprise, right? So who's the jury going to believe here? Let's bring in our guest. She's a retired FBI special agent and also someone who was kind enough to share a personal story with us last time she was on the show. Jennifer Coffindaffer is here. And Jen, you shared that you have been affected by sleepwalking, and you blew our minds when you shared last Friday that you had actually walked next door to the neighbor's house and ate a meal all while sleepwalking. So having that background and the personal experience, what do you think when you see this case against Mr. Elliott?
Well, I can say from firsthand experience, sleepwalkers can do a multitude of tasks and anything they would normally do if they were awake. My brother sleptwalked, and I shouldn't call it sleepwalking because you can do all sorts of things. My daughter also has parasomnia, and she just recently, only in December, opened up her cell phone, wrote 3 lines from a paper that she was getting ready to write, and closed her cell phone. She had written it in the note area, Julie.
Wow.
And didn't realize it till the next morning when she woke up, opened up her phone, and her notes was opened, and she wrote it at 3:30 in the morning when she was sound asleep. I've seen her climb curtains. I've seen her walk, saw my brother walk. I don't know what I ever did firsthand, because when you sleepwalk or have a parasomnic event, you don't know until you're told because somebody saw you or there's evidence of Twinkies on your hand, which is what happened with me when I was young.
The Twinkies. Yeah. Well, and Jen, what you just shared about your daughter backing up, I had this aha moment for a second. I'm sure many of our courties did too. The state hanging its hat on his cell phone activity. And what you just shared, wow. I mean, someone can be very precise on a cell phone. Your daughter did it. What do you think when you hear this testimony?
you know, what's so disconcerting is this young man is being judged as if he was awake. But if it was a parasomnic event, he could have done a multitude of tasks. It's not like they are saying he was on his cell phone researching how to commit a murder or where you should stab somebody or how to cover something up. No, supposedly he was browsing YouTube. Could he have been doing that? Could he have locked his phone still in that parasomnic state? We don't know, and this person doesn't know if it's accurate.
Jen, this is such helpful information because I think this is one of those cases where, you know, as I like to say, we don't know what we don't know, right? If we haven't personally experienced or know someone close to us who suffers from parasomnia, it can seem like, what? How does one do a stabbing in their sleep? But here, parasomnia is a real thing that affects real people, just as you told us, like you and your family members. I have a clip of the two experts where you'll hear a little bit of a back and forth, the two differing opinions, but the defense expert saying that Mr. Elliott did not have conscious intent to harm his sister Megan on that night. Take a look.
He doesn't remember getting out of bed, grabbing the knife, going there, and he doesn't even remember the first entry wound.
Okay. Well, you say he doesn't remember that, but that's not what he told police.
There were 2 wounds. I never heard him, and if it's there, it's there, but I've only heard him talk about a single thrust.
He had cognitive abilities, came back to him very quick, you know, way too fast. He immediately concluded that he was the one who did it. I've never had a case before where it was done within minutes of the incident. So that's some pretty fast thinking.
You know, and speaking of the aftermath, Jennifer, as an investigator, what do Benjamin Elliott's actions tell you after the fact, how he shares immediately with Dad? He was dreaming, so he says, when this occurred. He's extremely upset and trying to understand what happened. What significance do you think of the statements, the emotions, him staying put, not, you know, running and hiding somewhere? What significance do you think that all has in terms of whether he knew what he was doing at the time?
I think it's very significant because having this experience and seeing this experience with my family members, when you come out of it or when it's discovered or they tell you about it, you really have this sense of total confusion. It's a horrible way to be where you're wondering, I didn't do this. You know you didn't do it, only you did do it. And so I really feel sorry for Benjamin if this was a true parasomnic event, because of course he's going to be confused. And of course, at some point, he's going to realize he did that and be absolutely in a state of shock. At least that's how I have felt whenever I've been told that either I did it or when my daughter climbed curtains, as an example, and I had to redirect her, not wake her, but try to redirect her. And then I spoke to her about it in the morning. It's actually very scary.
It really is. This is really a helpful insight you're sharing with us, Jen. I've got a clip from Dad. Let's take a look.
What did you do when you saw that?
I asked Benjamin what happened, and he told me he stabbed Megan.
Did he say anything else about it?
No.
Then what happened?
I started to go into the room. I thought maybe I could help, and I saw Megan's face, and she looked horrible. She was gray. It looked like she was in a lot of trouble.
The state is hanging its head on the time, how when he places the 911 call, she is long gone. Jen, do you think there is an explanation for that with parasomnia?
Well, I think there's an explanation medically. I mean, if you get stabbed in the neck and it hits your carotid artery, you are going to bleed out so quickly that, of course, you're going to die very quickly and become gray in the face very quickly. So that makes all the sense in the world to me. And as far as when he would have woken up and when he would have made different realizations, I think all of that is in a lot of question, but we're only talking about 30 minutes as far as I can tell from the event time to the call time. And I know that may seem like a long time, but depending on when he came to consciousness, if again, this was parasomnic, it could have taken a while. I wanted to say too, Julie, there's been 2 other prime cases, Kenneth Parks, Brian Thomas, that also killed different individuals, one with a knife, Julie, and they were found innocent and acquitted because of parasomnia.
Wow. Thank you for all of that. All of the insight you're sharing. As a medic, too, you're also a medic, Jen, and someone who's been affected by this. This is really important stuff to understand. Thank you so much for everything. And my friends at home, be sure to check out Jen's new show, Break the Case, with Jen Coffindeffer. It is awesome. We'll see you again soon. Thank you much. Coming up next here on Opening Statements, could the jury selection process tip the scales for Kouri Richins? We'll talk about it next. Two innocent children put to bed,
only to awaken to the sound of gunfire.
Now a father stands trial accused of shooting his own kids in their bunk beds, killing one.
I hope that this individual feels the full weight of the criminal justice system and never sees the light of day.
Court TV takes you inside this tragic case,
as a jury must now decide the fate of this father.
She met up with acquaintance 2 at a Maverick gas station in Draper and purchased from him 15 to 30 round green-blue pills, which she understood to be fentanyl.
1 or 2 pills might be accidental. 20 or 5 times the lethal dose is not accidental, Your Honor. That is someone who wants Eric dead.
Finding a jury of local Utah folks unfamiliar with the case of Kouri Richins could be tough. Let's talk about what's tipping the scales in her upcoming murder trial. We know she's accused of poisoning her husband, Eric, and then writing a children's book about grief. During a hearing on Friday, the jury questionnaire was discussed in great detail with the lawyers. At one point, get this, Richins' defense team said that potential jurors could be intimidated by being questioned in front of the defendant.
I'm just not sure that doing it in writing rather than offering a range and creating a safe space to just describe how they feel, which is what would happen in individual dire, get them talking. Some people feel this way, some people feel that way. Where do you feel?
I think writing it on a computer sitting in your home is a much safer space than sitting in a room with how many of us here and being forced to answer that. A lot of people aren't going to want to say, yeah, I'm pressured. They're not going to, they might say it on here. They might be more comfortable on this forum than they're going to be sitting with a judge and a whole lot of attorneys staring them down, and Ms. Richins staring them down. Now, she's not going to stare them down. You know what I mean. She's going to look very polite as she sits here, but you understand my point.
Saw her reaction there to that about the stare down comment. Now, the judge ended up making some tweaks to the questionnaire, but said that it wouldn't go out just yet because Richins' legal team plans to ask to change the venue. They want the trial to happen in Salt Lake City. Now, this is due to a ruling from the state Supreme Court in Utah saying that jury selection would be chosen from the local pool, but the trial done remotely. Okay. The trial moving forward, though, it's set to begin in April someplace. TBD. All right, so let's talk about getting that impartial jury for Kouri Richins and how this should be done. Let's bring back in our legal eagles, Tommy Pope and Kirk Nurmi. Okay, so Kirk, what do you think the best way is for Kouri Richins to get a fair and impartial jury to hear her case?
Yeah, first of all, I'm going to disagree with their attorneys, but they certainly have my sympathies. The idea of a questionnaire is a good one. It gets some information out. It may make people open up about certain things. But ultimately, in the end, this idea of not doing it in front of the client, to me, is a disservice to the client and could ultimately make them ineffective down the road, because the trial's going to happen in front of the client. They're going to want to assess how potential jurors react to their client in real time, in real life. So this idea that they want to shield their defendant from the jury, to me, doesn't make a lot of sense. But an important point here, Julie, we're not looking for jurors that don't know anything about Ms. Richins. We're looking for jurors that haven't made up their mind about the case. And ultimately, when you think about that, the presence of the potential jurors and Ms. Richins is important, because people can get senses or feelings by being in the same room and draw those conclusions. So those attorneys really would be better served if they wanted to provide Ms. Richins with effective assistance of counsel by doing it in front of the jurors with their client there.
Yes, I agree with you completely, Kirk. And you could see how Kouri Richins was even shocked at that comment about, they wouldn't want her staring at them. You and Tommy both know how oftentimes defendants can be very effective with their mannerisms, their looks, all that during jury selection. And I would think Kouri Richins may be one of those people, because it's not like, she doesn't look like Charles Manson or somebody who looks terrifying, and she looks like a nice lady, huh? Tommy Pope, your thoughts on that, please, having her present.
I agree with Kurt. I noticed post-COVID, when we would have a conversation, I want to Zoom all the time, because just like we're doing now, I like to look at your face, see your reaction, see if you're understanding what I'm saying. It could be one little facial expression that a juror does when they walk by the counsel table. It could be anything but that's a lot of information. Unfortunately, in South Carolina, we don't have voir dire other than questioning. We have very limited voir dire, very limited opportunities to do that. Another thing, Julie, you need to filter out is people who want to be on the jury because of the publicity. And that's a tricky one. People that are eager to serve normally are there for the wrong reasons. They normally have an agenda, whatever it may be. And it's like Kurt said, their job is to set everything aside and be fair and impartial. Doesn't mean they hadn't heard about it, but can they set that aside and be fair and impartial? And I agree with Kurt. I think you got to look them in the eye sometimes, and the judge needs to look them in the eye to see if they believe that's truly the case.
Great points. Let's dovetail off of that last one you made, Tommy, with the idea that could there be some stealth jurors that have seen or heard about this case? Kirk, your thoughts on that, safeguarding that, either way, no matter which side you're on, you don't want anyone coming on your jury for the wrong reasons.
That's always a concern, especially in a high-profile case like this, because people maybe they follow it. So that's one of the things that a questionnaire does in an efficient way in terms of court time. You might ask people, do they watch court TV, right? And hopefully they're watching this morning, right? But at the same time, you want to know what their viewing habits are. You want to know maybe they've heard a little bit more about it. There's indirect ways to get an understanding of their knowledge of it. Do they go to true crime events, things of that nature, because that can really be telling in terms of just getting that gut or hunch feeling that this person knows about it. Or one of the questions I've been gutsy enough to stand up and ask in my career, standing there on a jury and say, you look at my client, you see her, based on what you see, do you believe she's guilty? And some people will actually have an opinion formulated that they can't really hide with that confrontational question. And ultimately, that kind of confrontation can help weed some jurors, covert, either direction, off the jury panel.
That's a great point, Kirk. Jodi Arias looked like a nice lady. We all know what she was really like. We'll leave it there for time's sake. You two are wonderful as always. Kirk Nurmi, Tommy Pope, thank you for everything this morning.